if you want to ask the question, can you send me a message on the chat box just to me? There I know who want to answer the question. Otherwise, I'll just pick randomly.
Sure, I can direct it to your attention.
Yeah.
So whatever question that's in the chat box. Okay.
Also, you're gonna read the question, Cheng?
No, you will read it out, but I will message privately to you the questions if I see them.
Yeah. I mean, I can see from the Q&A function.
Okay, but the chat box might be a bit messy, right?
Okay, yeah.
Alright. So we have started the webinar. Good afternoon, everyone. A very warm welcome to our webinar on the risks and opportunities of third-party funding in international arbitration. As many of you have known, third-party funding has become increasingly popular in recent years as means of financing international arbitration proceedings. While this method of funding can offer many benefits, it also possesses certain risks that parties should be aware of before deciding whether to pursue it. Today, we have brought together a distinguished panel of experts in this field to explore the various risks and opportunities associated with third-party funding in international arbitration. Without further ado, I would like to invite the moderator of the session, Ms. Sue Kim. Sue is based in London and has 20 years of experience working on a wide range of projects in the engineering and construction industries in the UK, the Middle East, Asia, and Australia. She has been recognized by Who's Who legal construction expert witnesses and has been appointed as a quantum expert witness in litigation, international arbitration, adjudication, and mediation, acting for both employers and contractors. She is a fellow of the Chartered Institute of Arbitrators, a fellow of the Royal Institution of Chartered Surveyors, a practice member of Academy of Experts, and a RICS accredited expert witness. Ms. Sue, the floor is yours.
Thank you very much, Chang, for your kind introduction. Good morning and good afternoon, wherever you're joining from. I'm so grateful to AIADR for this great opportunity to moderate today's webinar. And I hope all of you can gain some insight from our three excellent speakers today. And if you have any questions, please do feel free to leave them at the Q&A section. We will deal with them at the end of our session. So I have pleasure to introduce our three speakers today. Our first speaker is Andrew Jeffries. Andrew Jeffrey, I'll call him AJ today because we have two Andrews today. So since 2011, Andrew has served as an independent arbitrator dealing with a broad range of commercial disputes covering in particular power, energy, infrastructure, and construction projects. He's currently a panel arbitrator for AIAC, SIAC, ACICA, and PIAC, and is based in Australia. Andrew was previously head of Dispute Resolution Asia for Allen Overy, based in Hong Kong. And in 2003, he was appointed a Deputy Registrar of the High Court of Hong Kong. He was a member of the Law Reform Commission of Hong Kong, co-authoring the report on the potential to introduce conditional and contingency fees in Hong Kong. He's also a qualified expert determiner. He also acts as a training consultant teaching commercial arbitration. Our second speaker is Mr. Andrew Parsons. Andrew is a specialist barrister, mediator, and arbitrator with a commercial background and over 30 years of experience in work concerning business, property, finance, and commerce. Prior to practicing at the bar, he worked as a money and corporate finance broker in the City of London. In 1998, he was one of the first English barristers to become an accredited commercial mediator. Since then, he has conducted or acted as a specialist advocate in thousands of mediations in the UK and internationally. He's a fellow of the Chartered Institute of Arbitrators and a liveryman of the Washford Company of Arbitrators. He has conducted or acted as specialist advocate in many arbitrations, including hybrid arbitration mediations in the UK and internationally. Since 2008, he has been a member of the ADR panel of the Bar Council of England and Wales. He's also a past and current chair of the UK Southern branch of the Chartered Institute of Arbitrators. Most importantly, in his spare time, he sketches cartoons and writes stand-up jokes and routines. Our third and final speaker, not the least, is Mr. Shreyas Jayashima. He's an advocate, arbitrator, and mediator, and also founding partner of Arna Law LLP. Sharias read law at the National Law School of India University and was a Shivenic scholar at the University of Warwick. With over 20 years of experience in litigation, domestic and international dispute resolution, Sharias has advised and represented clients across a variety of industrial sectors before various tribunals and courts, including the Supreme Court. He's a trained mediator and has been appointed as an arbitrator in India and internationally. In addition to acting as a co-counsel for the Republic of India in 2 significant investment treaty arbitrations, Sharias regularly represents clients in domestic and international commercial arbitrations. Next slide, please. So today we have set 2 main questions to cover today's topic. But before we start to go into question 1, I'd like to set the scene. Assume that attendees today have varying degrees of knowledge and experience in third-party funding. So for everyone's benefit, I'd like to briefly set the scene with this question. What is third-party funding in international arbitration? Third-party funding in international arbitration is the system whereby a third-party funder agrees to pay some or all of one of the parties' arbitration costs. Such financing is provided in return for reimbursement of the funder's direct cost and a share of any sum recovered from the resolution of the claim. The use of the third-party funding in international arbitration has grown significantly over the last decade in many jurisdictions, including the UK, the USA, and Europe, and in the most recent years in Hong Kong and Singapore. Especially in the current uncertain economic times, one can expect its use will continue to grow. The increased interest in funding for international arbitrations is coming from both parties who require funding to pursue expensive claims and from funders themselves. So for claimant, the expense of pursuing high-value, complex arbitration claims and the uncertain economic conditions make third-party funding an attractive and necessary option. Or some claimants would not be able to bring their claims without some form of external financing, or others seek funding to share the financial risks of the arbitration process. The third-party funding is one of the most current and controversial issues in international arbitration. So let's say in case of a favorable award, the third-party funder is generally remunerated by a previously agreed percentage of the amount of the award. But on the other hand, in case of an unfavorable award, the funder's investment is lost. So you can see the huge risk associated with this third-party funding. So during today's webinar, our speakers will explain the use of third-party funding in international arbitration in different jurisdictions and some of the benefits and risks of third-party funding. We hope to provide some guidance on how to manage those risks and some practical tips for parties entering into a funding agreement. So let's move on to our first question. Our first question is views from different jurisdictions. As I introduced our speakers at the beginning, we have 3 excellent speakers who have experience in various jurisdictions. For example, Sharias has experience in predominantly India and Singapore and also internationally. Andrew Jeffrey, AJ, has extensive experience in Australia and Hong Kong and also internationally. And also Andrew Parsons has experience in England, Wales, Asia, Europe, USA, the Middle East, and North Africa. So, Sharias, floor is yours.
Thank you very much, Sue. Thank you to AATR for this opportunity. It's frankly quite inspiring that the vision of ALCO, the Afro-Asian Legal Cooperation Organization, is translated to this contemporary age, and perhaps is befitting that it, in a way, preceded the information age, and we are able to now have a delocalized, real-time practice which is collaborative on what is increasingly known as appropriate dispute resolution. So there is no sales pitch for one form of dispute resolution as being always perfect and fit for purpose. Our role as professionals is to shepherd parties' interests from one to the other. And as this ecosystem develops, we are seeing the economic imperative of third-party funding making a stronger case for itself. The jurisdiction of India, where I am speaking to you from today, has a somewhat conservative approach to third-party funding. Only about 4 states out of 30, close to 30 states in India have formally legislated and expressly recognized the practice. And then there have been a few decisions of the courts which have acknowledged, and most famously one of the Supreme Court, which have acknowledged in a wider the prevalence of third-party funding. And there is at least one case so far, and I'm sure it is going to grow, of a high court recognizing and enforcing an award that has been obtained by the enforcer by way of an assignment. Presumably, there exists a funding arrangement behind that assignment. And so the practice of seeing awards as assets has well begun. This earlier notion of it being barred by champerty and maintenance there is some movement away from it, but it is not entirely decoupled from that idea yet. So it is still in it's a progress is being made. I must say that there are some other exceptions to champerty maintenance, even in common law, such as insolvency and bankruptcy. And we have a very thriving insolvency and bankruptcy and R&I ecosystem in India, where we are increasingly seeing resolution professionals identifying awards or litigations as assets, as claims as assets. And so presumably there is an acceptance of bidders for those assets who would either be investing their own money or indeed money from third-party funds. The underlying challenge, insofar as India is concerned, before I move quickly to Singapore, is that it may be safest for domestic dispute resolution to be funded through a domestic fund, that is an onshore fund in India. And there is still some hesitation as to the ease with which, let's say, a foreign funded procedure in India could easily take its proceeds out after the successful execution of an award. Having said this, there are still instances where this can happen. And one quick example of that happening very rapidly and frequently is in the area of shipping, where multiple high courts have foreign exchange related bank accounts where deposits can be made if there is an arrest of a vessel or cargo on a vessel, and rapid settlements take place. What part of that industry is funded is not a matter that is fully disclosed, but there is a high level of economic activity in that space. Moving very quickly to Singapore, which is, of course, one of the world's most premier dispute resolution ecosystems. They, from 2021 onwards, have made amendments to their civil law, and third-party funding is clearly permitted in arbitration proceedings, court proceedings, applications for stay, and even proceedings before litigation before Singapore International Commercial Court. But in the interest of time, I will hold off saying more on Singapore, just to say that there are SIR guidelines, and there are about 13 odd funders which are listed on the website, which are happy to be compliant with it. With that, I will hand it over back to you, Sue.
Thank you, Shreyas. That's very helpful. AJ, what can you please share your views, please?
Yes, certainly. Thank you, Sue, and thank you for that kind introduction. Good morning, good afternoon, or good evening, everybody. I think a theme of what we'll talk about and try to illustrate today is there's a distinct journey for third-party funding, starting from those jurisdictions which previously or today may still uphold the principles of chumpity and maintenance and be very reticent or even forbid third-party funding or conditional fee type arrangements, to those that have completed their journey or are very much further along the path, such as Singapore, as Shreya says, and I think Hong Kong falls into a similar category. And there are shades in between, and different jurisdictions are developing at a different speed and are at different places along the journey. So with that overview, in Australia, third-party funding is very much permitted in a wide variety of forms, and is very much thriving in the litigation sector, which I emphasize. The old principles of chumpity and maintenance have gone, save for a few Australian states which technically still have it, but higher court jurisprudence has pretty much put a stop to any objections on those grounds. So the wide variety of third-party funding types of arrangement or lawyers' funding fees are all very much permitted. In the litigation sphere, it is growing in popularity and, as I say, thriving. The number of cases funded by third-party funding arrangements has gone up by about 8% a year for quite a few years now, and comes to something like 7% of the total litigation for which third-party funding would be at least a possibility. So ignoring, for example, criminal cases or family cases. And it's thriving the most in class actions, which is really where the action is, as it were, on third-party funding here in Australia. And about 50% of class action cases are now third-party funded. Funders are very highly regulated in Australia, which is something of an Australian way of doing things. We're quite keen on regulating everybody doing everything. A third-party funder is treated as a sort of investment bank or financial services company, and has to abide with a wide array of regulations and Securities Commission oversight and so on. And the government is at the moment continually looking at ways to tighten up those regulations. I think a particular concern at the moment is there's a feeling that third-party funders and the lawyers that work with them are taking too big a slice of the pie, especially in class actions, and the government is looking at tightening the regulations to clamp down on that even more. But we do have, as I've said, no win, no fee from the lawyer's point of view is perfectly fine here. And we get those American style, or at least I think it's an American style, adverts on your television. Have you been injured? Call us now. No win, no fee, which I think actually promises slightly more than it's going to deliver. But again, it's very much alive and part of the legal landscape. Contingency fees, on the other hand, are not allowed, with some very small exceptions in one state. So we haven't gone quite that far. Looking at the arrangements, and we'll come on to the scene on arbitration, there is generally no obligation of disclosure, either that there is a funding arrangement or who the funder is, or the terms of those funding. So it's very much, there's no rules on this, with a couple of exceptions that I'll talk about. So you're back on general principles of law and arbitrators' discretions and so on. On the arbitration side, I'm pleased to say that AKICA, our main international arbitration institution, brought in rules in April 2021, which do expressly deal with this. Article 48 makes third-party funding costs expressly part of the costs of an arbitration, which fall within the arbitrator's discretion to award. And there are also in Article 54 rules on disclosure. It's compulsory in an AKICA arbitration to disclose that there is third-party funding and who the funder is, together with any change. But that's where it stops. So the normal rules on allocation of costs, on how security for costs should be approached, and conflict of interest approach still apply. So that's a KICA, which has made on its rules a good step forward. Our mainly domestic institution, the Resolution Institute, came out with new rules on the 1st of January 23. So just a month ago, but amongst the busy work of their rules committee, they thought it wasn't necessary to do anything specifically for third-party funding arrangements. So again, you just fall back to generally accepted principles. So that's where we are. I have to say, whilst litigation third-party funding is thriving, from an arbitration point of view, it's a case of the shop is open, and most of the tools that people will need to make this a thriving arbitral jurisdiction for third-party funding are there. But so far, the take-up is very limited indeed. The rules have changed only fairly recently, and I think people are still catching up with it. But as we'll talk about in the next section, I think there's a lot of potential there, but not a lot of shoppers in the shop at the moment. Thank you.
Thank you, AJ. It's really interesting to hear the funders in Australia are highly regulated. So let's now move on. No, sorry. Sorry, floor is yours, Andrew Parsons. Sorry, I shouldn't have missed you out.
It's okay. No problem. I'm going to be quite brief, actually, because I think that a lot has been said. What's interesting, though, just picking up on several of the points already made, is that from my perspective, it's quite right, as AJ said, that there are different countries, I would say, struggling in some cases to catch up with the financial market that has opened up. And that financial market has opened up pretty much worldwide for funding arrangements, really on the back of worldwide recession, because when money is tight, people cannot fund. Sometimes international arbitration, we are talking large sums of money to fund a claim or a counterclaim. So the argument as to whether third-party funding is a good or a bad thing rages on. But guess what, guys, girls? It's here, whether you like it or not. The real issue, it seems to me to be internationally, which countries are going to recognize the fact that it's here, and how are they going to deal with it and embrace it? One of the key issues is it's hard to actually give a statistic about how many cases are third-party funded, precisely because of the point that AJ mentioned, which is the disclosure of the existence of such an arrangement. So different jurisdictions have come to different views of that. I mean, in 2014, the International Bar Association issued some guidance on conflicts of interest. And it's interesting that third-party funding was considered in that context, because an important point that arises if a third-party funding arrangement is there, certainly from the IBA's point of view, a third-party funder is equivalent to a party to the arbitration. And therefore disclosure of the existence of the third-party funding arrangement and importantly, the identity of the third-party funder is necessary to avoid conflicts of interest. As I say, I see with in some cases dismay, sometimes amusement, how different jurisdictions are grappling with such concepts. I would say best practice would be that you do have disclosure of the fact of the third-party funding arrangement and the identity of the funder. I think Singapore is ahead of the game, so is Hong Kong, because they actually have leaned towards disclosure of both of those things. I think that is now pretty much normal in those jurisdictions. Strangely, and I think probably to the shame of the UK, there's no actual code or legislation that requires the disclosure of the existence of a third-party funding arrangement or the name of the funder, so far as UK arbitration under the Arbitration Act of 1996 is concerned, which is a surprise. At the moment, the 1996 Act is under review by the Law Commission, and one hopes that one of the things that's introduced is an amendment to the Act which deals with third-party funding arrangements, but we'll have to wait and see. So that's kind of my general view, and I've touched upon the UK position. no win, no fee is definitely very common here in the UK, certainly very common in the USA, where in fact I think they invented it. In fact, they probably invented third-party funding. The Americans are a bit of a whiz when it comes to different financial instruments. Is it a good thing? Well, who knows? We can perhaps deal with that, or when we're dealing with the second question about risks and opportunities. But that's my sort of general view of how I see third-party funding around the world. It is here to stay, and different countries are catching up. My own thoughts are, one hopes that at least the different countries will have, in the end, a uniform approach to this, which will involve disclosure of the existence of the arrangement and the name of the funder.
Thank you very much, Andrew Parsons. Apologies again. So let's now move on to our second question, which is risks and opportunities of third-party funding, with the in line with main title of our webinar today. So there are obviously benefits of having third-party funding, such as access to justice and financial support. But as our speakers already mentioned for our first questions, we've seen numerous issues raised by the involvement of third-party funders in international arbitration proceedings. We can name a few examples, such as arbitrator conflict of interest due to non-disclosure of the involvement of third-party funder in the process, and security for cost. So we'd like to hear more from our speakers today. So our first speaker for this question is AJ.
Okay, thanks again, Sue. In terms of the risk and opportunities, I'd just like to go back in time a little bit to illustrate how the opportunities have grown. We've touched on this already. As Sue mentioned in the introduction, one of the more pleasant things I got to do when I was in private practice was to be on the Law Reform Commission in Hong Kong. And in 2007, we produced a report looking at whether Champerty and maintenance should be changed, which was then still very much in force in Hong Kong, and whether conditional or contingency fees should be allowed. And surprising as it may seem to look back now, the answer was no. And the main reason was there was absolutely no appetite at all from the legal profession to upset their rather nice arrangements of just charging hourly fees and being paid without getting into the risk versus reward game. We couldn't find any insurers after the event insurance providers who were prepared to come into the Hong Kong market to fill a bit of a gap there. So the conclusion was there's no appetite for it. There's no need for any change. And obviously with that, and with Champerty and maintenance still in place, third-party funding in Hong Kong was pretty much going nowhere. Well, as you've already heard today, there's been a radical change. At least 2 Law Reform Commission reports later on the subject, third-party funding is very much alive. The HKIAC is putting in place, or has put in place, rules and codes to deal with it. Legislation is in place, and the traditional rivalry to keep up with Singapore is alive and kicking. So there's been a huge change, which I think illustrates to me what I would call the opportunity, the first of the opportunities, which is this is here, it's here to stay. It is happening, and it's very likely coming to a jurisdiction near you if it's not already there. If you're a funder, if you're looking for funding, if you're a lawyer involved in this process, the opportunities are growing, and the places where you can successfully set up and operate on a third-party funded basis are growing steadily. And I think also we're talking about arbitration today. Arbitration, in my view, is quite an attractive proposition for third-party funders, which again, I think if you're involved in arbitration, third-party funding is something which is perhaps a little step behind court litigation in a lot of places, but is growing and will grow. From a third-party funder's point of view, the fact that mostly there won't be any appeals, there's no Court of Appeal, there's no Supreme Court, adds to the certainty and the risk-reward, risk containment process that a funder will think through in deciding whether to fund, a measure of confidentiality. It's the sort of process where there can be a lot of arbitrations with a lot of money at stake, which funders like to get involved in. And comparatively speaking, against litigation, the well-established regime for enforcement under the New York Convention provides a bonus. So I think for arbitration in particular, there is a lot of opportunity here. Arbitration is a third-party funding friendly mechanism, and I'm sure there's a lot more to come. I'm not sure whether this is really a risk or an opportunity or just a roll of the dice, but as we've also heard, there's a great diversity in the position at the moment. So you may end up in a jurisdiction where third-party funding is not possible or very limited. You may end up in one where it's very possible and very advanced, and depending which side you're on, that may be a good thing or a bad thing. You may have to disclose your funding, the status of funding, and even perhaps the terms of the funding agreement, or you may have to disclose nothing. Is that a good thing or a bad thing? At the moment, it's a bit of a roll of the dice, but I am optimistic and picking up very much on what Andrew said, that there will be a gravitation towards a norm, if you like, that over time things will develop in jurisdictions in terms of arbitration rules and arbitration laws, that there's something develops of a common standard. And of course, there'll always be jurisdictions that are behind or a little bit ahead. But if we think back, it's not that long ago that people hadn't really heard of emergency arbitrators or expedited rules. And then one or two arbitration centers says, well, let's try this. And it caught on. And now most arbitration sets of rules have these provisions or are catching up. And in my view, we're likely to see the same thing with third-party funding as the snowball goes on. But just a couple of risks, I suppose, not to lose sight of. It's easy, particularly talking about this enthusiastically today, to lose sight of the fact, and those that have done any or some third-party funding cases will know, be aware in the enthusiasm of having somebody else to pay for your case, you lose a lot of control. As I say, for those who've been through this once or even several times, it'll be relatively obvious. The claimant that sees the television advert that gets a big third-party funding class action together needs to appreciate that the pursuit of the case, the settlement, whether to make this particular point or not, is partly and even to a significant extent out of your control. And quite often corporations or even individuals will say, like, enough. This is costing too much. It's taking too long. Let's throw in the towel. And then your funders who want their pound of flesh at the end of the process will be looking at that and thinking, well, actually, this is a good case. We should carry on. Or perhaps more likely the other way around. The belligerent litigant with a vested interest and perhaps a personal interest will want to carry on, and the funders will say, enough. You know, the evidence has come out now, the merits are not there, we're not going to fund this anymore. So be aware, it carries a downside. It's not all an easy process or an easy win. And there's also something of a downside for defendants. The classic defendant or respondent in an arbitrations tactic is, of course, delay and frustration. If we make enough applications, we throw enough costs at this, the poor litigant will run out of money and go away, or even the corporate litigant will get fed up and the board will say, you know, let's just let this go and move on. But that tactic is going. And how that shifts the landscape of litigation, particularly for in insurers or those operating in a consumer sphere where there's likely to be a lot of cases, the balance is shifting, and that's a risk for those involved in arbitration or even litigation in that area. And I'm not sure where the balance to that is or what the response to it should be. In particular, it's still very rare to force a third-party funder to pay if the case is lost, the successful, usually respondent or defendant's party, mostly because certainly in arbitration and in a lot of court cases, those third-party funders are not party and are not within the jurisdiction to be made to pay, and that's not what the arrangement is. Should there be a change there? Is that part of the offset for allowing more, perhaps vexatious, but certainly more litigation to go forward? I'm not sure, something to think about. There we are. Those are some of the opportunities and perhaps downsides there may be. Thank you.
Thank you, AJ. It's a very interesting comparison with the emergency arbitration. So next speaker is Andrew Parsons.
Thank you, Sue. Right, let's take a pause for a second. Let's let's see what a third-party funder actually is. In my view, a third-party funder, put simply, is a gambler. That's it. No more, no less. They are in business to make money out of a claim or a counterclaim. That is the business, and they are playing the odds that the claim or counterclaim will be successful, and they're putting their money up on that basis. As AJ said, however, that although they come bringing gifts of cash, there is a price, and this is where you can see the opportunity of gaining funding to bring a claim or a counterclaim that you might not otherwise be able to bring because you do not have the funds yourself. But the risk that comes attached to it is inherent in the nature of the third-party funder. The third-party funder has a different agenda potentially to the party. And there are a whole host of risks that arise there. So I would say, by all means, explore third-party funding if it's appropriate, but be aware that your third-party funder will have a different agenda, and you need to manage that very carefully. Also be aware that if you do have a third-party funding arrangement, if you have a respondent who is properly represented, and I'll declare an interest that I've acted for a fair number of respondents where we've engaged in definite tactics to attack the third-party funding arrangement, in the sense of, once we're aware that it's likely to be there, we're seeking disclosure of not only the fact of the arrangement, but also we're doing it on the basis that we are seeking security for costs. So a big risk that arises in any case where you have a third-party funding arrangement is you can expect that the respondent will be considering an application for security. Now, how well that respondent will fare will depend on the jurisdiction, which I suppose comes back to AJ's point about you're going to have to take a chance of what jurisdiction you happen to find yourself in. But there does seem to be a general trend that arbitral tribunals are more open to considering applications for security than they used to be. Because frankly, third-party funding is becoming more common, and therefore applications for security are becoming more common. Whether or not how the arbitral tribunal will approach that, I've got a case example which illustrates risk, because there's so much uncertainty in the law here. The case I have in mind is actually it's an International Centre for Settlement of Investment Disputes case. It's the case of Hertsik and Turkmenistan. Now, the state of Turkmenistan was faced by an impecunious claimant supported by a third-party funder with a funding arrangement that it had discovered did not cover potential adverse costs awards. So effectively, the state of Turkmenistan was faced with the difficult prospect of, even if it were successful, the chances were it would have a costs award was just a piece of paper, not worth the paper it was written on. So unsurprisingly, it sought security for costs. Initially, the tribunal decided, yes, it would grant security because there was a serious risk that the costs would not be paid if the respondent was successful. And this is the first decision. I'll give you the citation, ICSID case number ARB 18/35, and it's the decision on security of costs of 27th of January 2020. Unbelievably, well, I say unbelievably, only a few months later, the same tribunal rescinded that order for security on the ground that it had become clear that the claimant faced insurmountable difficulties in obtaining funds to erase the security. So the very same facts, in other words, the impecuniosity, then caused the tribunal to say, oh, that will be unjust. It prevents the claimant from bringing the claim. that decision is the same case, but it's the decision on the procedural order number 5 of the 9th of June 2020. So in other words, within a 6-month period, the same tribunal did a 180-degree turn on its view about security for costs. I give this as an example because it shows just how uncertain this developing area of the law is, and it highlights the risk factors that can exist simply by fact that the third-party funding arrangement exists and is in play as part of the arbitration. Now, I don't know what people think about that. Is it right that security should be granted in a situation where it is 100% clear that if the claim is unsuccessful, the respondent will be left with its costs unpaid? Is that fair? Is it right? I don't know. In a different case, one arbitrator described the situation that I've just outlined as a gambler's nirvana. Heads I win and tails I do not lose. It's a memorable citation. That's from the case of RSM Production Corporation against St. Lucia, which is another ICSD case number ARB 1210, decision on security for costs of the 13th of August 2014. Now, do we want the gambler's nirvana or do we not? If anybody wants to raise a point of view in the chat box or ask a question later, I'd be very interested to hear what people have to say.
Thank you very much, Andrew Parsons, for sharing lots of warnings. I think the key message we can take away here is the funder is a gambler, right? Our last speaker is Shreyas. Shreyas, the floor is yours.
Thanks very much. This has been a fascinating exchange for my co-panelists, and I applaud them for their views, and you can see that they do not agree. Andrew Jeffries has perhaps a linear representation of backward or forward jurisdictions, and Andrew Palmer has the evocative phrase of, Andrew Parsons has the evocative phrase of as gamblers. So it falls to me to take the easy path in this to propose a middle ground. I agree with Andrew Jeffries that this is a phenomenon which is here to stay. And let us examine why for a moment. If you look at the family offices, if you look at the investor community that is looking for risk-reward ratios from their investment portfolio that is varied, there is a demand for products in their investment portfolio that exposes them to different types of risks. So it is, in a sense, merely spreading risk from an investor point of view across various asset classes. This just happens to be one. So I'm afraid I do not entirely agree with Andrew Parsons' suggestion that all funders could be gamblers, or that there is a gambler's nirvana per se. I think it is an option that is available. And here I do want to agree with Andrew Parsons first, which is a point that has not so far been raised, is the element of confidentiality. I think it's an open secret that the funders' world, the request for funding is, although it is termed as a confidential document, I have certainly seen it miraculously shift hands from the initial funder to which it was sent to, and then an offer being made by a little bird arriving from the shoulders of another completely different funder. And this does raise serious concerns as to, especially in an unregulated market, as to how confidentiality is maintained of the underlying material on which the investor or the funder has chosen to make an economic punt. Now, if the confidentiality is grossly undermined, then you may have little or nothing to go after. And we have seen many instances where confidentiality has been a matter of tremendous concern to the tribunals. Just as a brief example, there's the Arroyo case versus BP Exploration, from the High Court of England and Wales. There's the case of Tienvier versus Argentina, and there is South American silver versus Bolivia, and a case against Moldova, just to name a few. There's also the Guarachi America case versus Bolivia. Just to say that it is not me alone who's making this point, that there is an excessive concern that we need to, an excessive extra layer of caution that we need to wear when we deal with the issue of confidentiality and TPF. Now, the other element that has been spoken of so far has been TPF and the security for cost order, the mechanics of dealing with adverse consequences. And I think the point is well made that usually the UNCITRAL model law and its relevant domestic law enactments reflect on who is the award binding on, who is bound by an arbitral award. And if you look at that question, in most jurisdictions, you will find that the award is binding on parties and on those claiming through them. And so that latter part, which makes the award binding on those claiming through them, is taken to be the basis for which measures that may be taken against the parties may be taken also against persons claiming through the parties in respect of the award. And I think this is a link that sometimes is lost in case law, and if it requires statutory clarification, then that would be welcome. But separate from security for costs, I think there is also a question of cost itself. The entire underlying basis of TPF as an industry is to take the costs of litigating or arbitrating a dispute off the balance sheet. So you may get a few pennies to the pound or cents to the dollar, but at least you have them insofar as the assignor of the award is concerned. And here, therefore, there is a very keen layer of interest from the funder's perspective, which perhaps has not been spoken of very much in this panel. And again, attempting that middle ground, I will speak on behalf of the funder for a moment. That the funder is most keen to make sure that their funded award will deliver the return that is promised to them once they have a successful enforcement. Now there, we have seen resistance happen where there is, let's say there are costs incurred for the enforcement proceedings, and an important consideration from a funder's perspective is whether such costs of enforcement itself are recoverable in the jurisdiction where the recovery actions or the enforcement actions are being contemplated. And so we have seen instances where, for example, the case versus Georgia, I'm sure I'm saying the name wrong, but I read it as Kardasopoulos versus Georgia. Georgia advanced the argument precisely that the claimant's costs were borne by a funder, and therefore it was questionable as to whether those costs were recoverable in the first place. And so we're not here talking about recovery of orders for security for costs, but about cost recovery itself. And there are instances where, for example, in Khan Resources versus Mongolia, the tribunal concluded that the phrase legal and other costs in Article 40E of the UNCITRAL rules was broad enough to include the fees that the claimants had to pay to their lawyers and to their funders. But there have been other tribunals that have disagreed. For example, the Quasar de Valores versus Russia, the tribunal denied that the claimants had a right to recover their costs because the funder had funded the entirety of the cost of the proceedings and no contractual right remained for the claimants for reimbursement of these costs. I will not belabor the point by referring to further points, but I will say that there are certain industries which have shown that there is an easier and prominent acceptance of third-party funding. And I think it is not horses for all courses. There's no point taking a broad brush to tar the industry wholly or unwholly. Instead, I think certain industries, and I would call out one of them, is perhaps post-M&A arbitration. Post-M&A arbitration is a commercial matter. There may be representations which are breached or not. Ultimately, it's how the numbers play out. And I will say that one more challenge to the entire TPS industry is to grow beyond arbitration. And I'll end where I began, which is we're now in an era of appropriate dispute resolution. And so there may be instances where mediations are funded, where there's a hybrid procedure, which might travel between commercial courts, the arbitration and mediation fora, and funders may have a role to play in each of these fora. So I think an ecosystem is developing, which is making us all work a lot harder because there are no more tools in our toolbox, and we have to give them their due weight. Thank you, Sue, and apologies to both my panelists for disagreeing with them politely.
Thank you very much, Shreyas. No worries. Like, it was really interesting to listen to you. It's a really good debate amongst you anyway. So just to conclude, as AJ mentioned, the third-party funding in international arbitration is not an easy process, but the use of third-party funding in international arbitration has grown significantly, as you heard today, in many jurisdictions. So the third-party funding may be here to stay, but as speakers explained today, we need to be aware that there are inevitably certain risks associated with the third-party funding in international arbitration. So let's see if we have any questions. I can't see any questions. Feel free to answer any questions. We still have 6 minutes left, but whilst we're waiting for any questions to arise, I'll ask just one last question to each panelist. So we talked about these risks and opportunities in third-party funding in international arbitration. So what do you think would be the practical tips for the parties entering into this third-party funding agreement? Shall we start with AJ first?
Yes, thanks. So, just in our last couple of minutes, a couple of tips. The first, I think people will have worked out from what we've discussed today, although you may think at the moment that if you pick arbitration in one of the less advanced third-party funding jurisdictions, Ireland I know is fairly back down. You're assuming you're going to be a defendant. You think let's avoid third-party funding. I think really there's no point in trying to forum shop like that, because if you sign a contract today, by the time the dispute comes to fruition, it's very likely to have changed. And my other quick tip is the mentality, particularly on the funded party or claimant side, is very much to resist disclosure. We're not telling you we're funded. We're not telling you who it is. We're not telling you the basis of it. But actually do consider there can be an advantage to disclosure. Because if you have a case and you've persuaded We Fund Cast Iron Cases PLC to gamble on it and put their money behind it, if you tell the respondent that, they're going to look at it and say, okay, a serious money-backed outfit has looked at this claim, judged that it's got enough merit that they're going to put their money with it, and the claimant's now got the resources to see it through. And that's something a respondent might actually start to take account of and think, well, maybe we've got to approach this case a bit differently, and maybe we even got to settle it. So non-disclosure seems to be the default, but sometimes it can be an advantage. Just keep that in mind. Thanks.
Thank you very much, AJ. Quickly move on to Shreyas.
I feel I've had the mic for too long, so I must yield to Andrew Parsons. But before, maybe just say that the devil is in the detail. You need to, I would say, come up with a clear strategic options analysis as to whether funding is appropriate or not for your situation. And you must compare the various quotations that you receive from funders to see how they all stack up. It's not only vanilla parlor.
Great. Thank you very much, Shreyas. Last, Andrew Parsons.
Yeah, thanks, Sue. in the very short time available, one practical tip. Check the terms of any proposed third-party funding arrangement. And if the third-party funder is not willing to cover costs in the event of an adverse result, make sure you have insurance in place. If you have insurance in place, you're bulletproofing yourself from any kind of guerrilla tactic application for security for costs.
Thank you very much. I can't see any questions now, so we have 2 minutes left. So thank you very much to everyone for attending our webinar today, and thank you very much to all our speakers today. It was a very interesting debate. Thank you very much. Thank you.
Thank you, everyone.
Thank you. Thank you so much for the insightful panel discussion. We hope everyone have gained some valuable insights of the risks and opportunities associated with third-party funding. On behalf of AIADR, I would like to thank all the panelists and participants for their inputs to this session. It was a pleasure to have you with us. Thank you so much once again for your participation. Before we end the webinar, we would like to bring your attention to the AIADR upcoming courses and events. So first, I'd like to share screen. Oh, I think there is one question in the chat
just
box.
one last question.
Yes, perhaps you could
Yeah.
answer the questions before we move on to the.
Yeah, let's just quickly
promotional.
cover that. The question from Dennis McConnell asking, doesn't this third-party funding risk defeating the purpose of ADR, considering that the funders have vested interest? So who want to go first?
Well, there is obviously the risk that third-party funding may give access to justice, if that's what's behind the question. But at the same time, could argue it becomes risking access to injustice. You can see how that would be in the case that I mentioned as a case example. And in fact, the access to injustice point actually is something that appeared in one of the decisions in the Herzig case that I mentioned. I recommend you have a read of it, which partly may deal with your question.
Right, Cheng, time's up, but can we just deal with the second question quickly? The second question is, should the rejection of funding be disclosed too? Question mark. AJ or Shreyas?
There's no regime I'm aware of that has gone so far as to mandate a disclosure of rejection. I personally would not be in favor of such a regime.
Yeah. If there's not actually funding, there's nothing to disclose. So I agree with Shreyas.
I agree.
Thank you very much. Thank you.
Thank you so much. I think if there are no further questions, we will just move on to our next session. All right, so from the screen, as you can see, so we are AIADR also having some of our upcoming courses and events. So on 15 March, we will be having our third practical workshop on how to draft an arbitral award. Our president, Dr. Professor Sundra Raju, together with Dr. Nicholas Wigan, will provide a hands-on experience on how to draft an arbitral award. You can scan the QR code now to register or to join the workshop. And next, we will also be having on 25th March 2023, our fellow member, Jeffrey Alkinson and Dr. Adolf Peter will be conducting our Introduction to Arbitration course. All students, young practitioners, and anyone who is interested to delve into the field of arbitration are welcome to join. Do not miss the opportunity to take the first steps towards the rewarding career of ADR. Last but not least, we are also having our inaugural AIADR mediation training course that is happening on 28th April. Our mediation training course being the first Malaysian mediation course that is recognized by the International Mediation Institute, IMI, is designed to equip you with the necessary skills to become a qualified mediator. Register now to enhance your career in mediation. You can follow us on our social media to find out more details about our event and courses. And thank you so much and have a nice day ahead. Can we have a quick photo session with all the panelists as well? Okay, so 1, 2, 3. Thank you so much. And thank you so much for the time. We will end our webinar now.
Thank you.
Thank you.
Bye-bye.